Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Today we are going to discuss a case law, very good case law on the law of limitation discussed by the Honorable Supreme Court of India. Of course, certain principles, they are most important. Of course, the Supreme Court has agreed with the findings of the High Court. You can read this case as Brijesh KUMAR versus State of Haryana 2014. Brijesh KUMAR versus State of Haryana 2014. This is a case relating to Land Acquisition Act. You all very well know that now the name has changed right from 2013. Fair transparency, fair compensation, transparency, all these things. This Land Acquisition Act has been renamed. Previously, it was called as the Land Acquisition Act. So, the government of Haryana or the state of Haryana, they wanted to alienate certain land. The land is to an extent of 134 acres belonging to Brijesh KUMAR. So, they wanted to alienate the land. In the view of Brijesh KUMAR, the value of the cost of the land is as appraised by the government is very, very less. He does not wish to give his land. Of course, you can't help it. The government has got every power. Revenue department has every power to alienate the land. Only thing is, you can go for compensation. So if you are not satisfied with the compensation, you can file appeal. That's all. So therefore, they have filed an appeal in the High Court under Section 18 of the Land Acquisition Act. When did they file? This is the major problem. They filed the appeal after 10 years, 9 months and 29 days. 10 years, 2 months and 29 days. Heavy delay. So here the point of limitation. No doubt, Section 5 says the limitation can be condoned. The delay can be condoned with sufficient cause. If you are able to explain to the court the cause, and if it is in the view of the court, if it is sufficient cause or the reason is satisfactory, yes, the court can allow, the court can condone the delay. There are cases by the government where 3 years delay, 4 years delay has also been condoned, and there are cases where even 90 days delay has not been condoned. But of course here the Supreme Court so the High Court did not give or dismissed the condonation petition. That is, Limitation Act will apply. Now they approach the Supreme Court. So Supreme Court stated that every time, every day, so we are discussing about the limitation, the delay and latches, but still people are not understanding the essence of the limitation. You know the legal maxim. So that is interest republicae ut sut finis litium. Interest republicae ut sut finis litium. That means it is in the interest of the state that there should be an end to the litigation. Otherwise, the litigation will be continuing on. If you allow the people to file the cases as and when they like, after a period of 10 years or like that, the cases will go on. There should be an end. So for that purpose only, the Limitation Act has come into existence. But the court should consider the delay in the right perspective. They should not adopt an injustice-oriented approach. That means you file the case after 10 years. So you want the case to take down file? No, we are not. You should not say. You should not think like that. You must be having the justice-oriented approach. No doubt. And the court should dissect the difference between delay and inordinate delay. Delay may be due to so many things. Even the advocate also may try to cause the delay. Delay may be so and so. So, therefore, inordinate delay, if it is there, you have to find the reasons. So normally, inordinate delay may not be accepted. But please remember, sufficient cause, it is the condition precedent. if sufficient cause, if the court thinks that is the sufficient reason, even the inordinate delay will also be accepted and the delay will be condoned. So, but in this case, the compensation was ordered on 8/9/93, and after 10 years, 2014, they have come with this so-called appeal with a delay of almost 10 years. Then how can it be accepted? So the High Court, in the rights perspective, definitely it could not give the relief because it is inordinate delay. No doubt, Supreme Court also did not want to interfere. But these principles, what they say is, every day we have been discussing about the delay, latches and other things. It is not meant to destroy the rights of the parties, and no harsh and injustice should be done in condoning the delay, and they should take the liberal interpretation as far as possible. Liberal interpretation should be there, and the court should not adopt the injustice oriented approach. These are the principles which you have to take in mind, and this is one classic example. Of course, if the delay has been condoned, we would have been more happy, but Supreme Court did not do that because in the view of the Supreme Court also, it is inordinate delay. So the point is why they have approached the High Court and Supreme Court is the other people who filed appeals, they got benefit of 1.85 lakhs or so. So therefore, actually taking advantage or thinking that same judgment will come to them, they have filed the appeal but with inordinate delay, not accepted. Good case, please read it and enrich your legal knowledge. Thank you very much.